We are going to talk a little bit about restitution, maybe a little boring for some of you, but I would suggest that if you're not proficient in restitution and you're not seeking restitution, then you're probably not doing justice by your victims that you're working with. So we do want to give you a little bit of background. My name is Lana Taylor, for those of you who don't know me. I represent from the AG's office, the Utah Office for Victims of Crime. We appear regularly seeking restitution for the money that UOVC pays out on behalf of victims. We appear approximately 10 restitution hearings a week, so we get regular use of the restitution statute. And so we wanted to talk a little bit about restitution. I'll let Will introduce himself.
My name is Will Haynes with the Criminal Appeals Division of the AG's office. And so I handle restitution in the aspect of defending restitution orders on appeal. So we're going to talk through, hopefully you're aware that there is a new restitution statute last year, July 1st, it went into effect. It kind of overhauled quite a bit of the restitution system. And so we're going to talk about, kind of walk through that statute and also talk about some of the cases that have talked about what some of this means in the statute. So first we're going to talk about the issue though of which statute applies, whether you're going to be under the new statute or the old statute. Yes?
To adjust your microphone.
Okay, is it catching you better now? Is that?
Not the same, I think.
Yeah. This one's on, right? Yeah, you can hear it, but do you need a number? Does it catch all right there now? Sounds a little better. Okay, great. So you should be under the new statute now. It went into effect, as I said, July of last year, but we do get occasionally some challenges, some defendants arguing that the old statute should still apply to restitution hearings. And but I think most people, I think, are operating under the new statute here. But occasionally, if you do get a challenge, it was intended that for any sentencing that happened after July of last year, this new statute would apply. There's some language in here. Usually, you look to determine which statute applies. If it's explicit in the statute, you go with that date. And there's some reference here to the effective date, and also this phrase about this statute applying for sentencings happening July 1st of last year or later. Although in context, some people point out, well, this only talks about holding a hearing at sentencing or scheduling what you need to do at sentencing. So we have had some defendants push back and say, well, this doesn't apply. If you get that kind of a challenge, the controlling law you're going to look at is State versus Clark. This idea that to decide what statute applies, you look at what does the statute govern? Does you apply the law as it exists at the time of the event that's regulated by the law in question. So under the restitution statute, a lot of the times people talk about this distinction between if it's a substantive statute or a procedural statute. And this idea of substance and procedure, the idea is if it's substantive, it governs the underlying primary conduct of the parties that gives right to their primary rights and duties. And if it's procedural, then it's going to govern a procedural act that gives rights to procedural acts or duties. So in the sense of restitution, most of this is probably going to be procedural. The substantive, if it controls the amount of restitution, if there's any change in the statute that changes how much someone how much someone owes at the end of the day, that's going to be a substantive issue. But most of the changes probably aren't going to affect that. But the procedural changes, the process for determining restitution, or if you get a form, the process of the court's form, the form of the order that it has to enter. For example, the new statute did away with this distinction where the court has to do two restitution orders, court-ordered restitution and complete restitution. We'll talk a little bit more about this. Now there's just one restitution order, and that would arguably be a procedural act that the statute governs. If you do get an argument that the old statute governs, you can reach out to Lana or me. We have some briefing that you can look at to make these arguments. But basically, this is something that is, the courts have pointed out that the old restitution statute was unclear about whether restitution was discretionary or mandatory. But the new statute says that the court shall order the defendant to pay restitution to all victims either in accordance with the terms of the plea agreement or for the entire amount of pecuniary damages that were proximately caused by the criminal conduct of the defendant. And so you see those two legal bases for authorizing restitution, either an agreement to pay in a plea or the criminal conduct. You look at everything that the criminal conduct proximately caused. And we'll talk a little bit about these ideas, those ideas of criminal conduct, proximate cause, and then pecuniary damages. Look at three key ideas you want to keep in mind when you're looking at restitution. With pecuniary damages, the statute used to have this long list of definitions of what pecuniary damages were. It said all, demonstrable economic injury, but then it gave this long laundry list in the definition, and then also in other parts of the statute gave an even longer list. And in this situation, if death results, then funeral expenses and medical expenses. If someone loses their tools, or they're an independent contractor and they lose their tools, and you can give 5 days worth of lost wages. It gave all these sorts of examples of things that that sometimes were read as limitations. So now the statute just says pecuniary damages are all demonstrable economic injury, loss, or expense that result from the criminal act. And so it's a broader, all-encompassing definition here, and it's not meant to exclude what could have been what was listed out previously. It's essentially everything that's an economic damage as opposed to a non-economic damage, like pain and suffering. And there's another provision in the statute, again, that reiterates the courts are supposed to consider all relevant facts that establish an amount that fully compensates the victim for all pecuniary damages. Again, this idea of full compensation rather than a discretionary question of how much the court should be ordering here.
So we get this idea. We're supposed to include everything, right? Restitution for everything included. I get a lot of questions from misdemeanor prosecutors. So infractions too? What about these traffic offenses? What about where you've got property damage? Well, if you look at the restitution statute, there is included a specific definition of the criminal conduct of the defendant. And what do we mean by that? Well, strictly by the terms of that definition, it means misdemeanor or felony, a misdemeanor or felony offense for which the defendant is convicted. It specifically does not include infractions. However, infractions are included to the extent that it's criminal behavior for which the defendant admits responsibility for. This is really important when you consider that some of those infractions that you may have, especially if you have a domestic assault, you have some type of a traffic accident where someone's DUI and there's maybe a plea agreement where the charges are pled down to an infraction, there may be restitution on that. There may be significant injuries to a victim. And in those types of circumstances, you may want to include an agreement by which the defendant admits responsibility and that you later include a hearing for restitution. And the reason for this is nowhere in the restitution statute are there any limitations on the amount of restitution that may be ordered as per a particular level of offense. Restitution in justice court, even though it's a Class B misdemeanor, may be significant. Specifically with regard to some of UOVC's cases, we see restitutions in the thousands of dollars, tens of thousands of dollars, in fact, on some cases. And this becomes really important when you have, especially some of our plea and abeyance and diversion agreements. In the restitution statute, typically the restitution statute is only applying to cases where there's a conviction, but there are some specific duties for prosecutors which require the prosecutor to provide restitution information to the court when a plea in abeyance or diversion is entered. Also, we see in the in the plea in abeyance and the diversion statutes, specifically, a prosecutor must include an order for a specific amount of restitution. Now, this places a huge burden on prosecutors to be able to determine restitution up front if you're considering doing a plea in abeyance or diversion. In justice court, this can be quite challenging, especially considering the speed at which those cases move. there's often the question of, in justice court, when you're doing these plea and abeyances, can you just leave restitution open if you're not quite sure? Maybe this language doesn't quite allow for that. There's only one way in which you can kind of skip over restitution. And if the prosecutor specifically consults with the victim and consults with UOVC and can certify that there's no restitution owing. If you haven't done that, or if you're not sure that restitution is open, is that you ask that the court leave the restitution open for some later determination, that you get defense counsel to agree to determine restitution at a later time. The reason for that is if you have done a plea and abeyance and you haven't mentioned restitution, you haven't made any determinations there, the situation that I encounter most often is I come along after the fact, I file a motion for restitution for UOVC, and essentially it's an illegal plea if you haven't dealt with restitution, and either one of two things happens. Either the judge sets aside the plea, which no one wants to have happen, or the judge simply sets it for a restitution hearing for determination at a later time. So one of those two things are likely going to happen in your plea and abeyance anyway. Far better that you preserve the plea and abeyance and not have to risk having that set aside. And this becomes really something that you have some control over. I would always suggest to prosecutors, when you're looking at a case, when you're thinking about resolving charges, keep in mind a couple of suggestions. Either require a defendant to plead to offenses which are going to have pecuniary damages. This, quite frankly, can be really challenging. You may discover pecuniary damages on a charge that you didn't really quite realize, not until you got later on, maybe into the sentencing or post-sentencing phase. The other alternative, maybe a better alternative, easier alternative, is to require the defendant to agree to pay restitution for any of the charges, even charges that are dismissed, any charges included in information. Even one suggestion I would make, require them to agree to restitution for all cases that are included as part of a plea agreement. I can't tell you how many times UOVC will take a look at a case after disposition. You have multiple cases charged. We see this a lot of times in a domestic violence situation where you've got the same victim, you've got the same defendant, you've got multiple charges, especially where you've got multiple PO violations, and the prosecutor's doing a one-for-one. Well, UOVC may have restitution on both cases, but if you pled away one and didn't get an agreement for restitution, then UOVC is not getting restitution for that second case. And that's a situation that we generally like to avoid.
So, in contrast to the plea and abeyance situation, where you have the statute that says you need to have a specific agreement for a specific amount, so you may not get a judge that's going to agree to leaving it open. But in the plea context, when you're pleading guilty to something, that is an option to have the defendant agree to pay restitution, but then have the amount to be set by a hearing later. That's clear that that's allowed in the restitution, in the plea situation. But just be aware when you do that, you're not resolving restitution because the defendant has the right to challenge that amount. You're going to have a restitution hearing, and that they're going to challenge that. You may be able to come to some agreement later, but by agreeing in the plea that they're going to pay restitution, you still have to establish the amount and the causation there. There are a few benefits to at least having an agreement to pay restitution in your plea, though. For one thing, it does, if you're pleading, amending the count down to an attempt, the defendant won't be able to come and argue, well, this is an attempted crime, so there are no damages. If you're amending it down, they've agreed to pay restitution. Courts have recognized you're pleading to an attempt as a benefit of a plea bargain, but you also agreed to pay restitution. You recognize that your conduct actually caused more harm than just an attempted offense. It also provides the benefit of having a legal basis, that agreement to pay restitution. We talked about criminal conduct at the beginning. Restitution has to be based in the criminal conduct of the defendant or in an agreement to pay restitution in the plea. But to the extent you can get an agreement on a specific amount, that's going to be is going to save the event of a hearing later and the potential for challenging that on appeal. One thing to be aware of is that the prosecutor and the victim can agree as part of the plea that the defendant will pay less than the amount of damages that the defendant actually caused, but the court is not going to be bound by that. So there's a couple things to keep in mind here. If in this Hamilton case, for example, it was a securities fraud case. There was a Ponzi scheme where the defendant, Mr. Hamilton, was involved in this Ponzi scheme. He wasn't the orchestrator of it. He wasn't misusing the funds. He was simply lying to get people to invest money. And the prosecutor was able to work with Mr. Hamilton to get him to provide information and cooperate with the prosecution to go after the orchestrator of this Ponzi scheme. And so it was very beneficial to get that cooperation. They entered a plea deal where the prosecutor agreed to recommend that Mr. Hamilton pay only $38,000 in restitution, which is the commissions that he received. But he had brought in over $380,000 in investments from victims. And when the district court saw that in the PSR, the judge balked at this $38,000 figure, and he ordered the defendant to pay $380,000. And the defendant challenged that on appeal, and the Court of Appeals upheld it, said this is a recommendation that the prosecutor made and the defendant made, and the court is not bound by it. And because there was an evidentiary basis before the court, it upheld that $380,000 restitution order. And so if you're going to agree to a lower amount, there's a couple of processes, a couple of things to be aware. For one thing, you want to make sure that you're communicating with the victim here. It may very well be that this resolution that the prosecutor agreed to was a just resolution for the case, and that $38,000 would have been a just resolution, but you want to make sure that the victims are on board with that, because the victims are able to seek restitution in their own right. And there are cases out there that say that the victim can't enter in a settlement agreement and bind the state and keep the state from seeking restitution. And the flip side is true too. If the victim isn't involved in this agreement and doesn't agree that they're okay with less restitution, then just be aware of entering that agreement that the victim has the right to then appear and seek restitution in a greater amount. And there's, if you want the plea to be able to stick here, another thing to consider is Rule 11I allows you to present a plea to a potential tentative plea agreement to the judge, and ask the judge if they're likely to adopt this sentencing recommendation. That it may be worth doing that if you're going to go this route. So everyone's on board up front, everyone knows what's going on, so prevent the defendant from later challenging the plea, saying, I don't have, this wasn't a knowing or involuntary plea because I went in thinking this was the agreement and that's not what happened. Yeah.
How does this apply when certain victims have car insurance, medical insurance, and other things? I think a lot of prosecutors are misinformed of this.
Yeah, so if the victim has already been compensated, then they haven't, then they don't have restitution for that. The insurance may not cover everything, so you would look at what they have covered and seek restitution for what has not been covered, because they don't get, the case law is pretty clear, you don't get double recovery. So
usually out of pocket, if I want to solve a misdemeanor case that I'm handling, and I know that there is insurance, medical insurance, what I do, I contact the victim and ask them to send me the information about the deductible, out-of-pocket expenses, and I stay there. But that's the amount that I request as part of the resolution of the case, plea deal, and recommend to the judge. However, I've had some medical companies, like Select Health, send me an email with a $20,000 bill that the victim incurred from the assault or whatever. and I deny those, but I see them pop up here and there, that the insurance company try to get us to seek restitution for what they need to cover.
Yeah, I'll tell you a couple of things. Sometimes we see prosecutors actually filing motions for restitution for the insurance company, and that certainly happens sometimes. A lot of times when they do that, you'll get an objection from the defense arguing that the court can't order restitution for an insurance company. So most prosecutors that I see won't request restitution for an insurance company. You've got a whole insurance fraud organization that's out there, and that's exactly what they do, is seek restitution for insurance companies when there's a fraudulent situation, when they're considered a victim in that sense. But with regard to restitution for a victim when there's insurance involved, UOVC acts a lot like an insurance company. But what we'll see, and certainly if insurance pays for it, then UOVC won't pay for it, and the victim's not entitled to restitution for it. But there may be some things. You may have an insurance plan, a health plan, but they're not going to cover dental. So that, someone gets assaulted in the mouth and they have all this dental work, not going to be covered under their health plan. Mental health benefits, usually, they may have Medicaid coverage. Medicaid's going to cover for, a lot of those medical costs, but it's not going to cover for dental, and it's not going to cover for mental health. Plus, on a traditional mental plan, or physical health plan, they're still going to have those deductibles and that out-of-pocket costs that they're going to be responsible for, that they would be entitled to restitution.
So how do we educate the victims in certain cases, like criminal mischief cases, not necessarily DV cases, but for example, just neighbor fights or things like that. I have this victim who says, well, my neighbor shot my truck with a BB gun, and we said, well, okay, we're going to try to work out a resolution in this case, especially for restitution is our primary goal, and the victim refuses to file with his car insurance. He says, oh, my rate is going to go up, which we know it's not, because it's an act of another person. So how do we educate the victims in these cases, trying to say, well, by law we are required to cover, make sure that you get restitution for out-of-pocket expenses, but we should not cover you for the whole amount. You should get coverage from your insurance because you have it.
And I don't remember, are there any cases that address, there's nothing in the statute certainly that requires them to file with their insurance.
Yeah.
I do see defense arguing quite a bit that, well, they had insurance, so my client shouldn't be responsible for it. We see that with medical claims as well. Generally, I do see judges, well, if you had insurance, should have let the insurance cover it. But again, you also have judges that say, well, your insurance is a victim just like the victim is a victim. So I think it's going to depend. I'm not aware of any case law that really requires you to file with your insurance. And I think it's going to depend on your judge, quite frankly.
Yeah, I think the only thing that is clear is if they have filed with insurance and have gotten reimbursed, the victim doesn't get that also from the defendant. It's, only the deductible or what wasn't covered by insurance.
Question.
Yeah.
So, did you agree to amount less than the actual pecuniary damages? What if the basis for the amount of pecuniary damages is from a claim from UOVC? Can we negotiate a lower restitution amount than what the claim from UOVC is in accordance with the plea agreement?
Well, and I think, like you heard Will say, you'll want to consult with your victim. You'll want to consult with UOVC, because then you'll find me there objecting to it and making my own request for restitution, which I have done. Because generally UOVC, unless there's a real deficiency or unless there's something was paid erroneously, generally they're not going to stipulate to a lower amount. So certainly if it involves a UOVC claim, give me a call. Let me see if there's something that we can do. Also, and we'll talk about this at the end, but if it's a UOVC claim and you want to turn it over to me, I'm more than happy to litigate it in its entirety, and you can step out of that. altogether. So.
I want to talk a little bit about proximate cause now. The new statute makes it clear that proximate cause is the test. And sometimes you'll see cases that say there are two requirements of proximate cause, but for cause and foreseeability. There's also cases that say there's really the third component, and that's a substantial causative factor. In most cases, each of these won't be that hard to prove, but really a lot of the cases where we see a failure of proof on proximate cause, it really comes down to but for cause. This Morrison case is a good example where there was a criminal mischief charge where the defendant assaulted his roommate, and the roommate decided he's gonna move out, understandably, and the court ordered restitution for the moving expenses, paying a moving company application fee for the other apartment, and then the first month's rent. But in the restitution hearing, it became clear that the victim was going to move out anyway. He just accelerated his move out date by a month, so he moved out a month early. So the court said there wasn't proximate cause here, but really the failure was on the but for cause. Even had this offense not happened, the victim still would have incurred all of these expenses, except it came out to about $70 of increased rent, comparing his current rent to the new place. And so they affirmed that much, and also affirmed the lost wages as well. But so make sure you've got but for cause established, and then a substantial causative factor will be fairly easy to establish. Usually it's just an important or significant contribution, and on the flip side of that, it has to be more than just a negligible contributing factor. But one thing that's important to remember is that you can have more than one proximate cause. So you might have defendants arguing, well, this other thing was a proximate cause. It doesn't necessarily mean that the defendant's criminal activity was not the proximate cause. And foreseeability, a good thing to keep in mind too, is that the specific amount of damages don't have to be foreseeable. It's just the general nature of the damages, or general nature of the injury. Another thing to keep in mind too is defendants will raise the claim of superseding cause. So kind of bound up in the idea of proximate cause is the idea that there's not some other intervening cause that cuts off liability. And for superseding cause, if this other intervening cause, this other substantial contributing factor, for that to cut off liability, that has to be an unforeseeable event. And this Oliver case is a restitution case. It kind of walks through all the requirements for superseding cause. It's a helpful one to look to. And it emphasizes that this other event has to be extraordinary, really has to be unexpected. And criminal conduct of another person, even intentional criminal conduct, that can be a superseding cause, but it's not necessarily a superseding cause. Again, it turns down to whether that was foreseeable. So imagine someone is assaulted in a high crime area and the defendant leaves them there, and then someone immediately comes and robs them. Arguably, that's foreseeable that they're going to get robbed by the criminal and that was foreseeable, and that was an approximate result of the initial assault. Another argument we often see is whether we need to look to the Liability Reform Act in restitution. Defendants, we're seeing these arguments more and more, that the court needs to proportion fault to different people. And the Liability Reform Act, what it does is it adopted the comparative fault framework in Utah for torts. And the principle of comparative fault, if you remember from your law school classes, is if in a tort, one person commits a tort, if they acted negligently, if the victim of that tort was also negligent, if their negligence was greater than 50% cause of the injury that they suffered, then they can't recover from the defendant. And we see arguments, based on some language in these cases, that should apply to restitution hearings. If you get this kind of argument, I think the best way to respond to it is point to the language of the statute itself and say it's simply incompatible with the restitution statute to say that comparative fault should apply. Because comparative fault says that the victim, if they were 51% responsible, even though the defendant approximately caused their injuries or some of their injuries, the defendant doesn't have to pay anything, but the restitution statute says that the defendant has to pay for the entire amount of damage that they proximately caused. So you simply can't square these two statutes. And then there's a couple other cases there you can rely on, just courts pointing out this really doesn't really make sense to apply the Liability Reform Act to anything outside of torts. They give the example of assaults, just kind of an absurd application, but we do see this argument a lot. So there's some resources there for you to respond to that.
So a couple things that folks are surprised about in the restitution statute are there's some specific duties. First of all, specific duties ascribed to law enforcement. Law enforcement is supposed to gather restitution information and include it in their investigative report. Well, not a lot of restitution information is determined at that very early stage, but it can be a really useful indicator for prosecutors. If there's indication in there that the victim went to the hospital, then you have that you're on the back end. Either that's going to be a restitution claim from the victim or it's going to come from UOVC. There's specific duties of a prosecutor. Now this did not change. It wasn't a new addition under the changes to the restitution statute. There were some tweaks maybe to this, but under the restitution statute, a prosecutor, when you file charges, you have to contact all of your victims and you have to gather the approximate amount of restitution. You also have a duty at the point that you're actually entering a conviction to notify the court of that restitution information. And you might remember back under the old statute, there was this language that specifically said you had to file your requests for restitution within 1 year. And it really cut off a prosecutor's ability to seek that amount of restitution that might come up later on. This is gone. There's no artificial 1 year limit. The statute does prescribe terms in which the court has jurisdiction to order restitution, but there's nothing in the statute that limits you from seeking restitution any time during the statutory period. So I think that's important to remember here. Another thing to keep in mind is who is a victim? So the victim is not only any person who actually suffered the damages, but a victim includes UOVC, which again is why you have a duty to contact UOVC. It includes the estate of a deceased, and it includes a parent, a spouse, sibling, all of those individuals, which UOVC has always considered secondary victims. Those are individuals who may be entitled to restitution as well. So it gives you a broader base for which you should be inquiring of restitution. Also, there's an obligation for APMP. They should be reaching out and getting that restitution information. They should be specifically including that in the pre-sentence report. I think it's important when you get that pre-sentence report, at the time of sentencing, not only asking for that restitution to be ordered at sentencing, because that's really going to be a good snapshot of the amount of restitution that may be due at that time. Restitution may change. There may be additional restitution later on. But the presumption here is that restitution should be ordered at sentencing. And if restitution is not, then the court is required to set a restitution hearing. There's some judges that just simply don't do this. They're not complying with the law when they don't. But there's only a couple of considerations as to why the court waive this requirement. Either one, there's a stipulation about the restitution, so you don't need a hearing, or the prosecutor certifies on the record that there's no restitution sought by the victim in UOVC. Well, the only way that a prosecutor gets to certify is that they have specifically consulted with the victim and they've consulted with UOVC. We do get consultations, we get prosecutors reaching out to UOVC, but we don't get it very often. UOVC makes a concerted effort to reach out to prosecutor's office, send them notice when there's a payment made by UOVC. I specifically email prosecutors and let them know that there's restitution. You're shaking your head?
Months later. This is where we're seeing it. It's months after the fact.
I will tell you that UOVC sends a first payment notice. That first payment may be made later on in the process of your case. But when that first payment is made by UOVC, that's when they send that notice. They also send a notice when they open a claim, a subrogation notice. It's going to contain a zero amount on it. It's not going to show you any amount, but at that point they haven't made any payment. So they will notify you when they make payment. It's just their timetable for making payments may not travel as quickly as your case. And we'll talk a little bit about that again at the end. So give me a minute there. As a result of this, sure, restitution should be ordered up front. However, I would always suggest that you ask the court to leave restitution open. Statutorily, restitution remains open. You had a question over here?
So just had a question on that last slide where you said the court said that shall order restitution hearing. There are times when we as prosecutors know there's restitution, but we don't know an amount. So the judge says restitution hearing, we don't know it by that point. I mean, what's the process of that? Where the court set a restitution hearing, we still don't know it. We're working on with the victim, we've got thousands of dollars we're trying to sort out. Saying we're not ready, so let client know we're ready.
And one of the things that we always ask the judge to leave that restitution open. The court doesn't have to say that. There's nowhere in the statute that you have to say that because statutorily restitution remains open. But what I would suggest is that the court set a restitution review, that you at least set a date on the calendar. My suggestion would be set it out maybe 3 months. You know, if you've got a defendant that's on probation for 3 years, 3 months is a drop in the bucket, right? If it's a misdemeanor case, maybe you want to set it quicker. Out in West Valley, they set it 30 days out. In 30 days, we haven't determined restitution. We set it 30 days out, we set it 30 days out, we set it 30 days out. Well, it's kind of a waste of time. In a misdemeanor case, maybe set it out 60 days, maybe set it out 90 days. But in a felony case, set it out 90 days. Again, UOVC is not going to determine restitution. They're not going to pay restitution on the same timetable that your criminal case is going to run. But court should not be arbitrarily limiting, oh, you figure out restitution in 90 days and you let me know. We do have judges that do this from time to time. And if we continue to have judges do this, then I anticipate we're going to appeal that. Because the statute sets the jurisdictional time period for the court to order restitution, and the judges should not be limiting that. It would be our request. Oh, we've got another question?
Yeah, so our judges interpret setting restitution hearing as an evidentiary hearing. So
well,
they shall set it, but there's no limit on restitution. If you show up and you haven't gotten restitution from the victim, our judges are saying, well, this is the time for the hearing, you're not ready. So really what the judge is saying is, there's your time limit.
Ironically, my next point, we always ask that the court set an initial restitution review or a restitution scheduling conference. I understand that some judges have their own mind on that. The reason for that, and I think it's really important, when I file a motion for restitution, I expect that a defense attorney is going to file an objection. And by God, I expect that that objection tell me some legal basis. The rules of civil procedure require them to provide a legal basis for which they are arguing their objection. And I have a right to know what their objection is. I have a right to prepare for that hearing. So I ask that it be set for some kind of a review hearing. I want to show up. I want to know, is it records? Is that what they want? Is there a legal argument here? Is there testimony that we need to provide? If possible, I ask that that be set by WebEx. The fact that we're appearing all over the state, sometimes we have 3 restitution hearings all set at 9 a.m. on a Monday morning. They could be in Duchesne, they could be in St. George, they could be in Logan. We try to appear at all of them, and if we're moving to a time when they're all going to be in person, I think we're going to have some challenges. So a lot of judges are very accommodating and let these be set as reviews until we really determine that evidence is needed.
The statute is really broadly to order it or require us to consult with you on every case. It seems like that's more broad than is realistic. Meaning I've got 1,500 Walmart shoplifts that I'm reasonably certain you don't want me to email you about. And I might even have some domestic violence cases where my victim won't answer my phone calls. Do you have any guidance for how to apply kind of common sense while also not undermining your authority or our needs to coordinate with you?
And I'll tell you, a lot of that language was put in there to try and head off some of these issues at the pass So we weren't dealing with all of the issues and coming back, and like I said, setting aside a plea in abeyance for, you know, those kinds of examples. I'll talk a little bit about at the end about UOVC claims specifically and maybe things to watch out for. You know, when it comes to consulting with a victim or reaching out to a victim, I think a lot of prosecutors' offices have processes in place where when they're filing charges that they're sending out notice. They're sending out notice under the Victims' Rights Act, notifying them that they have a right to appear at important hearings and doing some of that. I think you're doing some consultation through that process. The interesting thing is UOVC is not considered a victim under the Victims' Rights Act. So UOVC is not regularly getting any kind of input from the prosecutors, which is why UOVC is so proactive to reach out to prosecutors on their own. UOVC is, and I'll provide some contact information at the end, but they're very welcome. They're very easy to get a hold of. Their response time is really good. If you need to know if they've got they've got an open claim, they can tell you like that. And it's as simple as an email. I think the prosecutors in your office who have reached out, and they can tell you, you know, we've certainly tried to be as responsive as we possibly can be to try and help streamline that process. So.
Another question, when we do get a notice from UOVC that they are going to be subrogating some claims, but the amount isn't known, what are we supposed to do? Do we need to file something with the court on notice, or do we just be aware of it? Because oftentimes I get those and the case is already resolved.
Sure,
yeah.
sure.
And so what's our role when UOVC has claims that it's...
We try to get, again, we send that subrogation notice out when we approve a claim.
Yeah.
So, you know, if it's going to be a homicide case and it's going to go on for on and on, right? We try to get that out to prosecutors so they have that in the back of their mind, maybe. They have it stuck in their file so that at some point, if they resolve the case, they include in that and in some kind of agreement that restitution will be included or paid, or there'll be a determination made by the judge. Obviously, in these quick cases, misdemeanor cases, your case is going to be on and done. After that, I'm going to track that case. I'm going to go in and I'm going to file a motion for restitution. So it's not always going to be all that useful, but it is a common practice that UOVC is going to follow to try and maximize where they can in getting the word out. So let's go back to the time limits that are actually imposed by statute. And the court has the jurisdiction to order restitution, and I should have made clear in this slide, maybe this if nothing else you keep in mind, it's the shorter of either the termination of the defendant's sentence, or if it's a first-degree felony, 7 years, any other felony, 3 years, or a misdemeanor after or within 1 year. So if you've got a misdemeanor, and maybe they've got OSCs and their probation actually extends for 18 months, you still only can order restitution for 1 year. If you have someone that goes to prison, they're in prison for 20 years, you can only order restitution for within the first 7 years. But the court can order restitution at any time during that. So this is why I get so worked up about the judge saying, oh, it's already been 90 days, prosecutor. You can't make a restitution request. Well, you can. Not only that, even if there's an initial restitution order made, the court can order a modification of that restitution order for good cause. And if more restitution has been incurred, there's additional costs incurred by a victim, additional ongoing mental health therapy, maybe there's an additional surgery that was needed, the court can still modify and order restitution. So. Oh, do you need this?
You can take this. Yours is cutting out.
Yeah, good to know. It's because it wasn't on.
Yeah, so the idea of, they have the statute saying the court shall set a hearing, but then you have these timelines. The idea of the hearing is that restitution doesn't get forgotten about or fall by the wayside, that the court actually sets a hearing, and whether, you ask for an, depending on the case, how much time you think you're going to need, but we have these outer deadlines of how long the court has jurisdiction to address that. So in the restitution hearing itself, when you get to a hearing, I think it's helpful to think about it as if it were a claim that you're going to prove the elements of an offense. You know, thinking about it, these three things you're going to have to prove. These are your elements for your restitution hearing. You have to prove that the defendant's criminal conduct proximately caused pecuniary damages to the victim. And each of those three things you need to establish, and you also need to connect the dots between those three as well. And, you know, running short on time, so I don't go into a lot of detail about this. You know, say the burden of proof is not clear in the statute, but I'd go with preponderance of the evidence. I think the case law bears that out, and hopefully we're going to get some appellate guidance on that soon. Another thing to keep in mind is the rules of evidence do not apply. And also, there's no clear case law on this, but the confrontation clause, it's likely that does not apply as well. I think the Utah Supreme Court has been looking at this about whether it applies to sentencing. Restitution is part of sentencing, and so this Drummond case makes the point that the case law is bending away from applying confrontation at sentencing, and I think that's implicit in the fact that the rules of evidence don't apply. Another thing to keep in mind is if you get a subpoena from the defendant to put the victim on the stand, you can point to Rule 14 of Rules of Criminal Procedure. You can argue to quash that subpoena if it's unreasonable. That's not going to you're not going to be able to be successful in every case. It's not like a preliminary hearing, which this Lopez case talks about, because there are some reasons that in a preliminary hearing, the default rule is the defendant can't subpoena the victim, but some of that analysis in Lopez doesn't apply to a restitution hearing. But absolutely argue if you have a victim of a sexual assault, any kind of victim where they need mental health therapy, you can absolutely make the argument that compliance with that subpoena would be unreasonable.
What about like individuals who perform work running damage on a vehicle that's damaged due to a criminal act? Sorry,
can you repeat that?
I had a case where the defense wanted to question the guy that did the body work to repair damage to a vehicle by the defendant. Does that apply similar to subpoenaing them, making them come and confront them?
Yeah, I think they're free to subpoena them. You'd have to show that it's unreasonable. I don't know. I think you'd have a hard case showing that that's unreasonable to put them on the stand. So
one of the things that I do in my cases, I work very hard to make sure that I never have to subpoena the victim or have the victim testify. I continually will use a declaration. The benefit of it is similar to what you do in a preliminary hearing with an 1102 statement. Is this not working? Not at all. Anyone?
Just making noise. It's worse than the other one.
What about now? What about now? Okay, so with a declaration, similar to your 1102 statements, you can have a sworn statement, just signed statement. It doesn't have to be a notarized statement. It doesn't have to be a full-blown affidavit. It can be anything from a letter, a statement, something signed by the victim. We'll do statements from a victim establishing that proximate cause, that the damages, the restitution that we're seeking were the proximate cause, were the direct result of the defendant's conduct. If you ever need a letter from the victim, we oftentimes will contact the Utah Crime Victims Clinic. Heidi Distel, maybe you may have worked with her in other capacity. She can help facilitate that. One of her attorneys may be able to represent the victim at no cost. They have victim counselors that can help work and facilitate that kind of a statement. Sometimes we get letters from the therapist showing that all of the mental health therapy that UOVC paid, that we're seeking in restitution, was related solely to the trauma caused by the defendant's criminal conduct and for no other reason. We'll also seek a declaration from the restitution specialist from UOVC outlining how all of the costs that UOVC is seeking for restitution are the direct result of the defendant's conduct.
So we're out of time now, so I'm just going to, these last few slides here, you can look through these in the handout. They essentially make the point of, thinking about what evidence you can use. You don't have to put witnesses on, but you can put witnesses on. You can rely on just the PSR. But the more evidence you're able to put on, the stronger your case. But again, make sure you connect the dots, not just prove the amount, but also connect it to the criminal activity and the proximate cause. That's where we see the most problems on appeal, is not connecting those dots and making that argument clear to the court. So that's my final thought, and I'll just turn it over to Lana. So.
I do want to go through a few more things, and of course you're welcome to leave. On the restitution, once you go to all this work and you get this great order of restitution for the full amount, one thing to keep in mind, if restitution can't be collected, there's no point. You've accomplished absolutely nothing, because under the changes in the restitution statute, all of the restitution has to be collected either by the court or by Office of State Debt. AP&P is out of the game. They won't do anything for you on probation. So, if the court's not creating that restitution judgment, restitution can't be collected. And it's that restitution judgment has to contain the creditor's name. It's either going to be the victim's name or UOVC. It's got to have, the court's got to have the address at which to send that restitution. I've seen restitution orders where the court has no idea where to send it, and they just hold it. They just hold the restitution. So that judgment information statement should be provided by the prosecutor. That address out of the police report should go to the court. And not only that, but the court is required to set a payment schedule. If you're not asking the court to do that, then you've spent that entire time on probation with not a penny being collected. And at the end of it, then we get to termination, and the money goes to Office of State Debt. Well, I will say, Office of State Debt collects a lot of money for UOVC, and we appreciate their work. But you've just spent 3 years on probation collecting nothing when you would have had this great opportunity to hold the defendant's feet to the fire. So getting that payment schedule is crucial, and having the court regularly record that. I'll see the court send out letters doing orders to show cause because the defendant is delinquent in not paying their restitution. Also, one thing, I see a lot of confusion about this when the time of sentencing. If a defendant goes to prison, all of the restitution has to go to OSDC. Statute requires it. There's no discretion there. And while the defendant is incarcerated, Office of State Debt can't collect anything. They can't collect anything until 60 days after the defendant is released. But there's nothing else that can be done. The court can't collect it. APP, corrections can't collect it. So that's just something to keep in mind. And I brought Chambray with me here today. If you've ever been contacted by UOVC, you probably got a letter from Chambray Anderson. She is our restitution specialist. And I wanted to talk to you just a little bit about UOVC claims, because they work very hard to distinguish crime-related costs. They obtain the police report, they match up the costs that are being requested, and their claims are going to remain open for 3 years past the original approval date, past when that original application is made. And so that's why you're seeing your cases are going quickly, and they're going to be continuing to make payments long after the disposition of your case. And this, quite frankly, is to be expected. If you've got mental health costs, a victim may be continuing to undergo mental health therapy, and it may continue after sentencing. It may continue somewhere down the road. And quite frankly, we see oftentimes victims very traumatized by the sentencing and continuing to need mental health therapy as a result. UOVC will generally approve 25 mental health visits for a primary victim, 15 visits for a secondary victim. And if you've got one of these cases, you're probably going to have a restitution request from UOVC. If you've got a homicide case, well, we're probably paid the funeral costs on that. If you've got a sexual assault case, well, UOVC paid for the sexual assault examination and is going to be coming along later on and making a request for restitution. If you've got a domestic violence where the perpetrator and the victim were residing together, UOVC probably paid for relocation costs. Also, mental health therapy, you're going to see on all of these. So it's important to think about when you're doing these plea dispositions that there's a real good likelihood that there's going to be a request for restitution, if not from the victim, then from UOVC. On your property crimes, when you've got a retail theft, when you've got some kind of forgery, you've got any kind of property associated crime, UOVC is not going to be involved. Those are not eligible crimes for UOVC to pay out on. So that's one way to distinguish between the two, right?
And I totally agree. I guess as a nitpicking a little at the statute, not a huge at all, but the statute seems to apply, well, directly state that we are supposed to reach out to you on the ones that common sense would dictate we probably don't want to spend energy on.
You know, we're always happy to be consulted. I know it's a burden on prosecutor. It's just a lot of work. For financial crimes, you're going to get a response back. We don't have a claim if you do consult. If you don't consult, worst case scenario, I'm going to move to set aside your plea in abeyance.
And to distinguish, by the way, when you say property crimes, if I have a domestic violence or criminal mischief case, is that the case where I know you probably aren't going to replace their door for them, but might you pay for the therapy and the other parts of that?
Absolutely. Yeah.
Len, I would add too, I think the statute says you certify that you've consulted with all victims, including UOVC. If you know by statute they aren't a victim because they can't cover that kind of loss, then I think you're fine to say you consulted with all victims.
Right.
Without looking at UOVC.
Right. But if it's criminal mischief, it may have been a domestic violence. You pled down to a criminal mischief, but that doesn't mean it's only a criminal mischief case. So, for our purposes. This is the letter that you're going to get from Shamray. This means that UOVC has paid out money. It's going to show you your categories. When they make an initial payment, they're going to send this letter. This is going to be, when you have all of these categories listed, this is going to be a letter that's going to come down the road. And it's usually going to be one that's going to come from me at sentencing saying, hey, we've paid out $23,000. We'd like you to request this at sentencing. If we have an initial restitution hearing set, I'll also file one of these. This is a redacted list of payments. It's not going to contain all of the juicy medical information, but it is going to tell you a bit of information. It's going to tell you the service dates of service for these medical expenses. If those dates of service match up with your date of crime, that can be really useful information. It's going to show you the billed amount. It's going to show you if the victim had insurance. If we actually go to an evidentiary hearing, I'm going to provide the other records, the records that do contain that medical information. But UOVC records are classified as protected records under GRAMA, and they contain private medical information of a victim. So I'm not going to provide those records without getting a protective order. I will handle all of that. I will do all of the legwork to do that, but I'm not going to release those either to a prosecutor or to a defense attorney or to the court without that protective order. You've got contact information. Bob has assured me that this information is available to all of you, all of this PowerPoint presentation. You have my information, you have Shamray's. If you'll send an email to that UOVC email address, we can get you a restitution notice or at least some kind of an answer. I say her turnaround time is an hour. If it was up to me, it would be within minutes. She doesn't like it when I say that. But we also have Will's information. And if you have any questions, we're always happy to do anything we can do to assist in seeking restitution.